biological age, and then my junior by 7 years as a lawyer. My Lord, but I bow for you. I don't want to be cited for contempt. My Ebon, yeah. I swear you, God bless you for always being there to mentor all of us. And the beautiful commander-in-chief, because he's ADC to the wife. And former Attorney General, Chief Akinolujimi, we always learn from your inexhaustible cup of wisdom. Paper you have presented today, which covered the field. You touched on all the issues. But let me take on one issue very quickly, which you mentioned. Although by way of aside, obiter, but I think it is at the cross of today's discourse, benchmarking, excellence, performance, and all that. If a lawyer would be damnified in court for arguing your client's matter or for attempting to argue your client's matter and refusing to withdraw the case at the prompting of the court, how does that amount to an offense for which a lawyer would be damnified in court? I do not agree. Not last year, not yesterday, not today, not tomorrow, and not forever. If that situation comes up again, I will resist withdrawing my case and disappointing my client, in whose case I passionately believe in after my deep research, not just as a scholar and professor of law, but as a forensic advocate. Sir, the Apex Court itself said in Adegoke Motors Nigeria Limited against Adesanya, you will find that reported in 1989, 13 Nigeria Wood Law Report, Part 109, page 305. He said, the Supreme Court is final. It's infallible. It's final. The Supreme Court is final. Not because it is infallible. It is infallible because it is final. Now, that was a powerful detour by legendary Justice Chukwudifu Oputa. But unknown to many people, he added a more or a stronger rider in the same quote. He said, we here sitting at this court, we are mere mortals, susceptible to errors and mistakes. Therefore, when a lawyer discovers that a case was badly decided, said a lawyer should be bold and courageous enough to tell us here to revise our judgment. So, tomorrow I will do it again. If I feel that a judgment that the Supreme Court had delivered earlier was not in tandem with the law or with justice, the Supreme Court has permitted me, Adegoke Motors, to come forward and say, revise this judgment. But the case I was dealing did not even tell the Supreme Court to reverse itself. I was even telling the Supreme Court to affirm an earlier judgment, not to reverse itself. Having said that, the other little point I want to make has to do with the Court of Appeal workshop that just ended and some of the wonderful salutary recommendations they made. One of them that I think we must take very serious has to do with pre and post-election matters. Where should they stop? They are of the opinion that all of them should stop the Court of Appeal. I humbly disagree. For pre-election matters, you can say that. But for post-election matters concerning governorship and senatorial elections, I want to say that they should find their way to the Supreme Court. Thank God we now have a full complement of the Supreme Court, 21 justices. I think one has left, but we still have up to 20. Now, take a look at the just scenario, Plateau State scenario. 23 legislators voted for by the electors were dethroned, and new faces that were never known to the electors were brought in to represent them, to represent the people. 23 legislators of the PDP were removed by the Court of Appeal on grounds that did not quite follow the extant law, which is that matters concerning primaries, internal matters, they are all within the domestic domain of a political party, and so are not justiciable. And that you cannot peep through the window to look into the affairs of your opponent. That is the law. When we are now saying that the PDP in Plateau State did not have any structures, which structures? That was an internal matter. But they used that to remove 23 legislators, senators, and House of Representatives and House of Assembly members. I think that is not good enough. The Supreme Court was so angry about it, though the case was not before them, that they made comments on them. I said this was pure injustice, miscarriage of justice. But you see, it could not be rectified because the Court of Appeal was the final court on legislative matters. I think the Court of Appeal should not be the final court. It should be the Supreme Court. You can stop unnecessary proliferation of cases by putting a very high pre-filing deposit fee. If, for example, you say, before you file this case, you make a non-refundable deposit of 10 million naira, I can assure you that only the best of such cases will ever find their way to the Supreme Court. But it's better than stultifying justice. I do not agree with that judgment. That is one. The second one I want to touch on their recommendation is that I agree with them that before any person is sworn in as a governor or as president or as senator or House of Representative members, the elections that challenge his victory must first be concluded and decided. Because once the person has assumed office, he begins to use the instrumentality, the apparatchik of the state to fight his opponent. So even if you are just going on, they will just be laughing at you. Let them go to court. I wrote an article on it, go to court. Everything that happens, go to court. So we must avoid the situation where the judiciary has become, in my words, in one of my write-ups, I called it judocracy, a system of government which is different from democracy, ably propounded by Abraham Lincoln on the 19th of November, 1863, as government of the people, by the people, and for the people. Today, I say on election matters, we should be careful, because judocracy has come to play where a president or governor or legislators are incubated, conceived, midwifed in the hallowed cause of our laws instead of through the ballot paper. We must be careful. Politicians must be careful to know that